Good evening. God bless each and every one on this evening. It is so good to have members here in the sanctuary with us on today. And those of you who are maybe viewing us by stream, God bless you on today. I hope you have your pads, your pens, whatever you're going to write on and take notes. On this evening, we are so privileged and blessed to have my sister, Attorney Wanda Adams, with us on this evening. You know that the Lord placed in my heart on this year with the theme Family Matters. So these are this seminar tonight is going to be dealing with some stuff that I think we all should know and have information about. So I'm going to give a word of prayer, and I'm going to turn it over to Attorney Adams. Father, we love you tonight. We thank you once more and again, God, for what you have done for us on this day, because you woke us up this morning. You've blessed us to come in the evening of the day. And we thank you now for all things. Now look on us, keep us, and bless us now, even during this time. Lord, give us wisdom and give us knowledge and give us the things that we need to continue to press further into the future. We love you now. We thank you now. In Jesus' name we pray. Amen. We'll now turn it over to our attorney.
Thank you, Pastor Edwards. And I apologize ahead of time if I appear to sound like a frog. This pollen is certainly winning the fight right now, but I'm going to do the best I can. But it is indeed a pleasure to be here at Shady Grove. I feel like I'm at home. I've been here many times. Pastor Edwards is dear to my heart, Miss Reed, um, Sister Berry. And so there are several of you that I know. Mr. Canty, who I have not seen in many years. But I always welcome the opportunity to come and speak to particularly our folks about what he calls family matters. And unfortunately, it's just something that we just don't want to talk about. We don't want to deal with until we're forced to. So when I have the opportunity to come and give you a little bit of information so that you're prepared for when the inevitable does come up, then you can make some informed decisions. Let me give you just a little bit of history about me. I am an attorney, practiced law for over 30 years. I retired 1 year ago. Praise be to God. But God did bless me with the opportunity to do a variety of things. I did the private practice. I did the city judging. And the last 18 years of my career was spent prosecuting in Greenville County. And that involved prosecution of adults and children. So again, I decided a year ago that I kind of had my feel of all of that. And so right now I don't have a practice. But again, I jump at the opportunities to come and try to provide some information. God said, so that you can make informed decisions. And one of the things that I want you to be aware of when it comes to family matters are you'll hear terms, if you haven't already, like estate planning. But one of the most important things that you need to be aware of during your lifetime is the importance of having a power of attorney. I cannot stress that enough. We will get into wills and trust in just a few minutes. But those are things that don't become effective until you die, for the most part. But that power of attorney, let me tell you the situation I was often confronted with as an attorney. I would get a call from someone who was at the hospital, and the conversation would start like this. My mom has had a stroke, and is she doesn't even know she's in this world, and we need to take care of her affairs. The first question I ask is, well, what kind of state of mind is she in? Will she be able to talk to me or communicate with me? What's the answer I'm likely to get? No. Therefore, we can't do a power of attorney. This state requires that you must be of sound mind. You must understand what you're doing. Because when you sign a power of attorney, what you're doing is you are giving someone the authority to do anything that you could do. That means sell property, cash checks, file your taxes. Anything that you could do, you're giving someone else the authority to do that. So you certainly need to understand what you're doing. And if you are so incapacitated that you can't do that, we can't do it that way. Therefore, you're then looking at a process through probate court. It's usually called a conservatorship. And it's a long, drawn-out, expensive process. Well, by that time, financially, things have probably gotten in such bad shape. You know, bills going unpaid or checks going uncashed. You know, money just sitting in an account and nobody can do anything. But that's what I used to see. And it was heartbreaking, but it's too late by then. So the number one thing you need to take care of during your lifetime is a power of attorney. Be careful by who you name as a power of attorney. That was the second thing I used to stress to people. You need to have it, but you need to make sure it's somebody trustworthy. Oh, I've seen accounts cleaned out. I've seen properties sold. And that's even sadder when someone thinks that they've done the right thing, started getting their affairs in order, but someone doesn't have the same agenda. So when you decide you need to do this, make sure it's someone trustworthy. So upon your death, then the power of attorney is no longer effective. Well, hopefully by the time you open your eyes up in heaven, you have a will and you've made some other decisions. Again, in South Carolina, South Carolina requires that you be at least 18 years of age, meaning the age of majority, and you also be of sound mind. Meaning, just like with the power of attorney, that you understand what you're doing. You know, and a lot of times people get confused, and what I've seen, especially with some of our older people, is that they think they can't execute these documents because maybe they can't read and write. You know, sign with an X. It's not required that you be able to read and write. You need to be able to understand what you're doing, though. And whoever is helping you prepare these documents, if I prepare that document for you, it's also my responsibility to explain to you what you're signing. So please when you're talking with, your elders or whatever, make sure they understand that just because you can't read and write or sign your name as a signature, that doesn't mean that legally you can't execute these documents, because you can. You just need to know what you're doing at the time you sign it. Now, 5 minutes later, if you have a stroke and again, you don't even know your name, that doesn't count. Long as you understand what you're doing when you sign those documents. So, will, your last will and testament. That is the document you use to decide who's going to get what. And I can't tell you how many times I've heard from my people, well, I ain't got nothing. I ain't got nothing nobody wants. They don't want this old furniture. They don't want that. There's no need for me to bother with that. Let me tell you. Say if Minister Angela here, if she got 2 children, and she got maybe 1 fork and 1 spoon, because they belong to you, one of them children gonna want it. I ain't gonna tell you to go and spend no money and get a wheel if you ain't got but a fork and a spoon. We gonna be real. But I use that as an example because we have to recognize that things are sentimental. What you might think that nobody will want, again, just because they belong to you. And it sets up a fight. And believe it or not, I would not stand in God's house and tell a lie. But I remember years ago, this lady came to me. When I tell you she changed her will about 3 times, all because of the flatware, the eating utensils. She get mad at the children and she be like, I don't want them to have it. Take him out, change it, give it to so-and-so. But that was important enough to her. So again, this is the instrument that would be used, again, for you to have your wishes carried out. And I'm sure every single person sitting in here or can hear me, you have worked hard for whatever you have. And you certainly deserve to be able to direct who's going to get what. How things are going to be carried out. And in a will, you can be as specific as you want to be or as general as you want to be. Some people choose to, if you got 3 children, say, I just want everything divided equally. The house, the furniture, the jewelry, let them decide. But now if you know it's going to be a fight, don't leave that mess behind for somebody else to deal with or to set up a fight with your children. Death is hard enough. We've recently been through that. My sister Kim and I, we lost our mother. But thank God I told her, I said, you don't have to leave a single thing to me, but whatever you're going to leave behind, make sure you've specified. And again, it just takes some of the hurt away because you don't have to make that decision. But again, you can be as specific as you want to be or you can be as general as you want to be. But now, just like I talked about the power of attorney being such an important document for while you're living, that will is just as important, but especially if you have minor children. I think it is just neglectful. That's how strongly I feel about it. That's the word I use. It is neglectful for anyone to have minor children and not make sure that they are taken care of if something should happen to you. And that last will and testament, it will allow you to name a guardian for your children. And then you can even take it even further than that and say, if that minor, and I always advise people, I just don't know many 18-year-olds who can handle coming into a good chunk of money. You can say, I appoint so-and-so to be guardian of my minor children or child, and that any money they might inherit, say, be held until they're 25. And so-and-so is going to be trustee of that money to make sure it's going to be put up and all of that, and they get it at whatever age you specify. So there are just so many things that you can, that document can be tailored to fit your family. But like I said, if you've got minor children, or even if they're not children, or someone that you care for, you know, say like a parent or whatever, make sure you put in place how you want things to go. But now I need to kind of give you a disclaimer about the one where you name the guardian for, say, minor children. That doesn't automatically mean that that person is going to get those children, but it carries a lot of weight. And I'm going to give you an example of how it carries weight. I remember, this was many years ago, this young lady came to me, and she was in her early 20s. She had just been diagnosed with cancer. As she sat across that desk from me, I was like, she's young. Other than this cancer, she's probably going to be fine. She had a child. The father had never been involved in that child's life. Grandmother was. So she named her mother, that child's grandmother, as the guardian. Well, lo and behold, she died several months later. In her 20s. Well, guess what happened? Dad showed up. Dad showed up. I want my child. I want my daughter. We went to court. And I represented the grandmother in a custody action. Most situations, him being the father, chances were pretty good unless we could prove he was just totally unfit. Chances were good he was going to be awarded custody of that child. But I presented that will. And what I said to the judge that day was that she thought enough about her child to make these arrangements. And this court needs to give weight to that. And that's what tilted things. And the grandmother was awarded custody. Mm-hmm. Mm-hmm.
And she had a young child, and the daddy had just got out of jail, but she didn't have a will. And so the mom, the child was with the mom. And so because the daddy came into play, we couldn't do anything but, because the child, she had the child as the beneficiary. And so with the child being the beneficiary and under 18, we could not give that money to either the mother or the father. But the father ended up having custody of the child. And so we told her that she would need to go to court to see if they could give her a temporary in order for us to release the beneficiary. So I understand about making sure that when you got small kids, that you make sure that you have it in writing.
Absolutely. Absolutely. And You know, those situations happen way too many times. Way too many times. Okay, so even if we not talking about minor children or vulnerable adults that you might be caring for, let me tell you how things go if you don't have a will when you die. Your next of kin. I'm going to use myself as an example. Okay, I'm single, I don't have children. Okay, so I die without a will, my next of kin would be who? Well, my parents. But because my parents are both deceased, then my siblings. Okay, if I didn't have any siblings, it would be like my grandparents. If my grandparents were deceased, it's going to be my aunts and uncles. If I don't have any surviving aunts and uncles, it's going to be my cousins. What a mess. That's a mess. I've seen where people died without wills, and it goes all the way down to, say, several siblings. You can have 10 people owning a house. Nothing can get done to the house unless everybody agrees. Then you might have to look at going through what they call a partition action through the probate court to get everything divided up. It's a mess. Brings me back to another example. Friend of mine that died many years ago. And I like to use examples because these are not examples that they're not foreign to us. Friend, a dear friend of mine, also was single, got sick, but had been caring for her nephew for years. But she never adopted him. So legally, he wasn't her child. But she'd had him since he was a baby. She dies without a will. Didn't have a husband. This nephew was the closest to a child as you could get. But guess who got everything? Who's the next of kin? Her parents. Her mama and her daddy. Her daddy she hadn't seen in 30 years. He walked off and left the family 30 years earlier. But he got half of her estate. That was not the way she wanted it to go. Right? And I bring that example up because, y'all, you know what we do. We take in each other's children, we raise them, but we never legally adopt them. And you can't love them any more than if they've been born to you. But if you haven't taken the step of legally adopting, legally they're not your child or your children. That's not the way the law looks at it. So again, that's something you need to consider. If you find yourself in that situation, and every single family has that kind of situation. If they're going to be there with you long term, adopt. And then they legally become your child. But that's what happens, again, when you die without a will. Yes, ma'am.
If you write something on a piece of paper and just have it notarized, would that hold up the probate?
No, not necessarily. Because South Carolina requires that a will be signed in the presence of 2 witnesses. One witness has to be a notary. Like I say, you need to be at least 18 and of sound mind. Now, there have been some situations where, if nobody contested, the court might accept it. But the language that's included with witnesses, most people, there are forms on the internet that you can print off, and some of them are sufficient and some of them are not, because each state's laws are different. So you want to make sure that whatever you execute is going to be recognized in this state. Otherwise, you just done this for nothing. So now what I recommend people do is, when you talk about writing something out, if you got, say, a lot of like jewelry, little personal things, write that out and it can be attached to your will. And that way you don't have to go through every single thing you own, because over the years you give away something, you lose something, you sell something. So a lot of times, just to keep from always having to update a will, that's a good idea. Make your list. Who's gonna get what? But again, I just don't advise. Yeah, I'm an attorney, and I've made some money over the years doing wills and doing, some estate planning. But you just don't want to. Once you've committed to taking care of your stuff, you want it right. You want it right. And what I've seen in those situations where somebody's written something, somebody would come and say, she didn't even know what she was doing. So-and-so had her right there. And again, a fight, a mess. If it's done properly, people might not like it. I did a will for a lady years ago. She just had messy children. And she knew that, though. That was reality of it. She knew they were messy. And she had given them everything she was going to give them. So whatever she had left, she decided how it was going to go. She said, hold on to the will until after I'm dead. Normally, you get your will, you put it up with your other important papers. Make sure you tell somebody where it is. I see that a lot, people. Somebody died. Miss Adams, do you have? No. We can't find the will. Yep. So when you get it, when it's done, make sure somebody knows where it is. But no, your original, because that's what's going to be taken to probate or whatever after your death. So that stays with you. And it's not filed. A lot of people think, you do a will and it's going to get filed at the courthouse. No. Because it's not good until after your death. So whoever you're naming in the will to take care of your affairs, who's going to be what we call a personal representative. Some people, they've heard executor. But whoever that person is, again, make sure they know where the will is. You can give it to them if you want to. But even if you don't want to do that, I always say, put it with your insurance policies, any other important papers. Well, when that time comes, people can put their hands on it.
What has to be recorded when it's done?
Okay. That's a good question, Kim. This is just a personal practice of mine. It's not required by law. But when I do a power of attorney, I record it. I record it at the Register of Deeds. That's where deeds to property and everything is. And the reason I do that is because Again, people misplace the power of attorney, and that way, if someone needs to know that you've done that power of attorney, it's on record. They can go on the internet and pull it up and print a copy off. So I started doing that years ago. So that eliminates that, that problem if somebody can't. Did mama do a power of attorney? Yeah, we did that for her years ago. It's going to be recorded if I did it. But again, it's not required. Again, it's one that has to be signed in the presence of 2 witnesses. You got to be 18 years old, and you have to be of sound mind. Yes, ma'am. Oh, yeah, you can. You can go, and it's like a $25 fee. But I just learned the importance of doing that. A lot of attorneys don't. Yes, ma'am. Now, I do what they call a durable power of attorney. What that means is I throw a whole lot of language in there. Medical records, HIPAA. Anybody goes to the doctor now, you hear that term HIPAA. And that's just a privacy law that will not allow the doctors, medical professionals or whatever, to share certain medical information or private information about you, unless you've given somebody else permission to do that. So I include all of that in that general power of attorney, so that, and what I tell you to do, once we sign that, I record it, or you go and record it, whatever you want to do, then I say, take a copy of this document to anywhere you do regular financial business, like the bank. Also, give a copy to your doctor, because there is language in the one I do that includes, the authority for them to share medical information with whoever your named power of attorney is. But you can take that a step further and do what they call a medical power of attorney. That is a pretty intense document, for lack of a better word, because what you're doing with that document is you're deciding on things like organ donation, whether you want a feeding tube, whether you'd want everything humanly possible to be done to keep you alive. And what I usually tell people with that is, you can go on the internet and get the South Carolina form. And you need to sit down with your family and do that form together, because they're just certain things that you're going to find some folk are just not comfortable with. So those are just decisions that y'all, I think, as a family need to make together. And I mean, as an individual, you certainly can just do it on your own. But personally, that's just the way I feel about doing that particular document. But in the general power of attorney, the durable power of attorney that I do, I have that HIPAA language in there, so your doctor can talk to whoever, you name, that kind of thing. Does that answer your question? Sure.
Living will, there's decisions he can make or she can make. If that individual has a living will, then those decisions can be made.
Yes.
So,
And the living will and the medical power of attorney are very similar documents. Basically what you're doing is you're giving someone else the authority, say for the doctor to come to and say, look, we've done all we can do. We need for you to decide what we're gonna do next, if anything. What I know with that, the HIPAA language, the authority for the doctors to talk with you, but I don't go into the specifics of the organ donation and the feeding tube and all of that. You can, again, the living will is, again, usually doctor's offices have those documents. And you know, now what I've noticed when you go to the doctor's office, now they ask you, do you have a living will? Yes, yeah, right. So, but it's just, I just think it's just such a personal document that, you know, you need to sit down with your family or, you know, your close loved ones and decide how we're gonna do this. Yes, ma'am.
Why does it have to be probate?
If a person has a will, what's the procedure of probate?
Okay. Basically, what you're doing is, with just a standard will, you're just directing how you how you want things to go. Now, there are certain things that will not go through probate. Say, if you establish a trust, say, like in the situation I gave, like the minor children. Now, probate, once you go in there with that will and they read in there that you've established a trust for these minor children, they're going to direct you, you need to get to a bank or whatever and set this up. But, like insurance money, that doesn't go through probate. That goes directly to the beneficiary. Trust, if you've established a trust doesn't go through probate. But you name this person to take care of your affairs, and it's going through probate basically for accountability. And because historically, we've just seen too many cases of people not doing the right thing. But there are certain ways you can avoid it. But it's very difficult not to be able to completely avoid going through probate. I'm gonna give you an example. This is a way you can avoid, say probate or say real estate. You can put it in a trust. Now it's gonna be expensive if you're gonna set up a trust. If you're going through a legal professional, it's going to be expensive because there's a lot more work involved that the attorney's gonna have to do. But I tell people who come to me, especially if you have, I'll give you a typical situation, you got elderly parents, and you help me with the time. Okay, just give me a heads up. You got elderly parents, or you're elderly yourself, and really getting up there in age, and if you anticipate that nursing home care or some kind of assisted living situation is going to be necessary, I tell you, you need to transfer that property out of the parents' names. Now, but you need to be mindful of this. If you do that, if you're gonna put them in a nursing home or whatever, then and you're gonna have to apply for Medicaid to pay for the nursing home care or whatever, if you don't have the money to privately pay. Most of us don't. You need to be ready for Medicaid to go back. I think it's 5 years now. It used to be 3. They're going to go back, and if you've made any transfers, say of property or any kind of major transfers, they're going to penalize you. Meaning, you might have to privately pay for your loved one to stay in that facility for several months. They'll tell you how long you have to pay. But sometimes it's worth it. Because if your loved one dies with that property still in their names, Medicaid's going to place a lien on it. And most of the time, the cost of the nursing home or whatever is going to eat up the cost of that house. So they're going to end up owning it. So, again, that's something you need to be thinking about in your estate planning. So, of course, if you've already transferred the big stuff, by the time you go, no need to go to probate. So, again, just, things, sometimes, things happen, we can't anticipate everything. But, but when it's like, Mama's, she's 85 years old. I mean, we know how she wants this house, she wants to have it. You might want to look at just transferring it out of her name so that the state doesn't get it.
Thank you. Some of our jobs offer legal insurance. Do you have any opinion about that, purchasing that legal insurance? They say if you pay an extra $10 a month, then you get free legal advice for anything.
I've certainly seen the benefits of it. I had a friend recently who had purchased it through her job, and it came in handy with some out-of-state issues she was having to deal with the relative. Because otherwise, I can't imagine what she would have had to pay to retain an attorney out of state. So no, I don't tell anybody not to do it. I wouldn't, personally. But like I said, I've seen the benefits of it. Like I said, that example I just gave you. And this friend, I couldn't help her because I wasn't licensed in Virginia where she needed to take care of some stuff. But through this insurance she had, at work, they provided her with some legal assistance in Virginia. So it's just a judgment call. Yeah. Yes, ma'am.
Recommended that we file a joint tenancy with right of survivorship. Can you talk about that a little bit, and is that beneficial in terms of having to go to probate or not?
Absolutely. Her question was, her attorney, when they closed on their house, the attorney recommended a joint tenancy deed. That's legally what it's called. And basically what it is that, okay, say Miss Reed and her husband, when they bought their house, then language could have been put in that deed where it's going to transfer to whoever survives the other one automatically. That's what that means. And that language has just recently started being used. If you look at the old deeds now, that was not the case. Those time it was like Miss Mammy Reed and John Reed, basically bought this house from so-and-so. So, but I certainly recommend it. If you got two people buying a house and you doing this recently, you need to ask for that kind of language. As long as you both consent, that's the way it will be worded. Yes, ma'am.
Years ago, I bought my home, and I have 3 kids that's grown now. And my will stated that it would be divided 33.5 cents apiece between my 3 children at my death. Is there anything I need to look at now, update or change anything? If I want it to stay as it is, do I just leave it alone?
No, if you don't, you still wanted to go 3 ways equally, there's nothing you need to do. But again, keep in mind that if you don't transfer that house, before your death, and it goes to the 3 of them, the 3 of them will own it equally. That means if a lot of people do that, so the house can remain like the home house. But what that means too is that the 3 of them need to work together. Work needs to be done on the house or whatever. It can't get done unless all 3 agree. And I've seen it go both ways. But a lot of times when when you're dealing with more than one person, there's the potential for some issues to come up. And when I've had clients in the past who've had those kinds of concerns, like, he might give them some problems, but I want him to have his part. So I would suggest, well, why don't you do this? It just might be easier. Just leave it to one, the one you know is going to do the right thing, is going to be the responsible one, who you trust to give the other 2 their part. But that can change too. That can change. That's life gets in the way.
Yeah, 'cause it's 7 of us, and my mom and my dad passed, and now it's all 7 our names on this house. And my oldest sister makes sure, the taxes is due, and this is your amount. And I said, okay. And then and if I don't send it to her, where's my money?
Yeah. So that can be a lot. Just to try to navigate with so many people. But I understand again why you did it. And yes, ma'am. Yes. Yeah. You're right. So you don't know how people will react. But you know your family. Sometimes, yeah. You're exactly. No. You're exactly right. And see, and the thing is, most of the time, you're not just dealing with your children, but if they got spouses. We come as a package. That's just the way it is. And I always say, pillow talk is something. With spouses, you expect spouses to make decisions together. So, but that certainly is that might affect your child's decision making. So it's just a whole lot of thought that you have to put into these documents. Yeah.
Good evening. This question kind of piggybacks off of the question that was just asked. When thinking about outlining your will to specify homes, for example, going to people versus it going to a trust. Can you talk about the difference in the financial obligations and what that might look like? And to shed a little bit more light on that, it's been said that if you leave it in a trust, then you don't have to pay like taxes or things of that nature on it versus the transfer via will. Any light would be appreciated.
No, that's not necessarily true. When it comes to trust, there are fees and costs associated with maintaining a trust. And of course it depends on how valuable the trust is. Versus just leaving something outright through a will. Rarely do I see estate taxes. Now, probate court, they have some fees that you pay based on the value of the estate. But there are certain things that you need to be aware of, even if you transfer, I need to go back to this. If you transfer that house out of your parents' name before their death, okay, it's not going to go through probate because the property has already been deeded. But now, if you're under 65 years old, you need to be mindful, you're not going to get that homestead exemption for the property taxes that your parents got. So a lot of people, they get hit with that. They be like, oh my God, I got a tax notice for $1,500, whereas your mama might not have been paying but $300. So you're gonna lose that tax advantage. So sometimes it just all weighs out. But no, there are costs associated with a trust too. But again, a lot of it just depends on the value of the trust, what somebody owned at the time of the death, and how valuable it was. Does that answer your question? See, I think I have.
Judge Adams, I got a question real quick.
Oh, yeah, sure.
Situation we're dealing with our family. We have a piece of property that's been tied up in my great-great-grandmother's name, still in her name. I've never met this woman, never seen her in my life. But we were the caretakers of the land. And we paid the property taxes. We've been paying the property taxes for years. We lived on the land for 12 years. But the family is in agreement that they want me to put it in my name. What would be the first move to have that property transferred?
Well,
Even the patriarch of the family is in agreement that.
Okay. What's probably going to have to happen, and this is just a guess of mine, is that whoever cleans this up for you, they're going to have to go back. Because what a lot of times happens in our families is that somebody will die with a will or without a will, and nothing ever goes through probate, so there's no history of who owned the property. That can go on for generations. So somebody, whoever helps you with, they're going to have to go back and figure out what's been done, what hasn't been done, and catch it up until now. So if your great-grandmama died and, let's say, without a will and had 8 children, yeah, her part would have gone to her children. But if she had a husband who also owned the property, he would have also gotten a part if he survived her. So you got to figure out who died first. You just got to work your way up until now. I did that, and I said, Lord, if you ever let me get through this with this one family, I'd never do this again. But, because, again, it was just, we ended up dealing with over 100 people. Over a couple of generations. Because nobody ever, people just died and never did anything. And so legally, you've got to establish like a chain of custody. Mr. Barnes, you know about, like in criminal matter, you got to establish who owned it here, and then when that person died, who got it, who's entitled to a share. Yeah. So I know that's probably not good news, but but that's in order for you to have a legitimate legal title to that property. That's what's going to have to be done. Mm-hmm. Yes, ma'am.
Which trust would keep your home, keep the nursing home from taking it if you don't put it in a child's name? Is there a way for the trust to keep it out of the nursing home's hands?
Well, I mean, it's you would have to, even if you kept put, say, your elderly parents, if you put the property in a trust, that trust is still going to belong to them. So if you go to apply for nursing home care, and again, if you're not going to pay privately, and you're going to need to apply for assistance from the state, they're going to do a search to see what you own. So even if you've put it in a trust, the trust still belongs to them. Does that make sense? You just need to transfer it out of their name, period. But like I said, be ready. I mean, you know, you got the homestead exemption issue. You got the issue of if they should pass away within those 5 years, whatever, that they go back and they're going to penalize you. But you just have to decide if it's worth it. Yes, ma'am.
Excuse me.
Mm-hmm.
Now, if a person experience a loved one that's very close and dear to you, and they pass on, went on to glory, and they put your name in their home or something like that, it's helped me on it a little bit like that, because I don't know too many things about that, you know. And they left your name and their home, you know. They gave you their home or something like that, their house. Where do you go from there? I mean, this has a lot to do with, we was talking about probation and stuff like that. Does it have anything to do with that? Because they left
Okay,
your...
so let me make sure I understand your question. So someone just named you as,
They want me to...
they want you to have the house.
Yeah.
But how did they say they wanted you to have the house? That's the important. Did they do it through a will?
Well, it's going to
Okay.
be worked on that way, perhaps, I'm
Okay.
sure.
Because, I mean, that's going to determine
Right,
whether it's going to be recognized or not,
right,
how that person did it.
right,
You can't just say, I
Right.
want so-and-so to have the
right.
house.
Well, I'm sure it's going to be that way.
Okay. Well, if that's the case, then you'll probably be going through probate.
Okay,
And then probate, they kind of walk you through, and then they'll
Right.
tell you when you get to the part
right,
where the property can be deeded into your name.
right. Okay, thank you.
We wrap up. One more.
Thank you. If this question is not appropriate, you can sidebar.
Okay.
But I'm thinking about a woman bringing children to a marriage and a man bringing children to a marriage. Can you talk about a prenuptial agreement and what you should or shouldn't specify?
It's important. But if, I don't want to get too deep into family law. But a prenuptial agreement basically is, again, it's a document or an agreement that two parties who are anticipating getting married, you've decided how properties are going to be merged or what's going to stay separate. Generally, unless you state otherwise, when you marry somebody, if you owned a house before you married them, that's your house. That's non-marital property. In South Carolina, you marry someone, but you already own, say, a house before you married him, that is non-marital property. But now let me tell you what happens if you get married, but then now you start letting him build on to the house, pump a lot of money into this house. That's what they call commingling funds. Commingling. So if the marriage doesn't work out, you go to court, then he has a legitimate claim. He's going to say, well, look, okay, yeah, she had it before we were married, or he had this before she married him, but he started letting me put all this money into this house. So if the court agrees, the court will find that it went from non-marital to marital, and you both own it. So I know I went a little further than the prenup, but a lot of times with prenup, again, you're dealing with properties that you own before you were married. If you're not planning to adopt each other's children, that's really not something that you address in this prenup because, again, there's still children who are parented by somebody else, biological parents. But it's just something, again, that's something you certainly need somebody legal to help you sit down and make sure you don't muddy the waters when it comes to marital versus non-marital property.
This is the last question. So once they're married, that house is non-marital property. That's what you're saying?
No. It's still non-marital property.
Okay.
You divorce, you said, no, I own this before we were married. So it's still, that's not marital property. But now if you start letting somebody again pump enough money in it and all of that, then it becomes marital property. But generally, anything that you buy while you are married is marital property.
Okay. So they get married, they move out of that house, and the person that he marries, she moves her children in the house. How does that work? And they are supposedly paying them rent for the house.
I think it's still going to be non-marital property.
Okay.
But generally the rule is, okay, if I had a house before we got married and he had a house before he got married, that property belongs to me, your house belongs to you. Now, we get married and we buy property together, that's marital property. But now again, if I let you go over there and start adding on rooms and all of that, then we taking a chance of if this marriage doesn't work out, this property's gonna change. Something, keep in mind.
Any other questions as we close?
Well, I hope I've answered most of your questions. And I hope you can now make, if some things were not cleared up before tonight, now you can make some informed decisions. It's so important. Like I said, death is hard enough. You just don't want to leave a mess behind. Okay, so now listen, I don't have I'm retired, but I am willing to do some wills because I want y'all to have them and I want you to have power of attorneys. I want you to have your affairs in order. So anybody who needs a will, a power of attorney, I want you to put your name here, pass it around, and a phone number. I will call you. So, because everybody's situation is different. So we can talk about what you need and give you some advice. And you want me to take care of it, I'll take care of it. And we'll talk about any fees or whatever. I won't break you. I can tell you that. Because I want you to have it. I want you to have it. It's too important.
Can we give our attorney Wanda Adams a wonderful, wonderful hand? We thank you for coming, and truly this is Family Matters, and I thank all of you for coming out on tonight. And everything that she talked about is just important. I always, as she gave examples of life stories, I can give you one. Life can change in a twinkling of an eye. And I mean, that's being raised in a normal household. It can change in a twinkling of an eye. I'll probably get slammed for it later, but I'm up here now. Just like myself, me and my sister, we're in a situation now, and we're trying to figure out how did we get here. And that's because things wasn't done in a proper manner that it should have been done. And I'm saying that to us of our age now, we need to get wills and we need to get these things in order, because before you know it, you're at the age, and if one of you passes on and goes to glory, and the other one of you remarry, you never know what can happen to you. You can get sick while you're married to that new person, and your children are on the outside looking in at everything that you and your family work to build together, and now they, will not inherit any of your legacy because someone else has come in and doing the do. So I encourage each and every one of us to get wills, do what we need to do to make sure that we look out for our children and our children's children. Amen.
Talked about, subsequent marriages, that's another thing. A lot of times we separate and we don't get divorced. That is real. People don't get legally divorced and go on. Again, I've seen too many instances where that's happened. Someone was married back when he was in the World War II or whatever. They stayed together a few weeks, never saw each other again. He starts a life, has children with someone else. They've been together 60 years. Guess what? He dies, but he never legally. She survived him, she shows up. Guess what? She's still a wife. That's right. And gonna get the wife's share of the estate. we have to take care of our business.
Tell them what our mama used to always tell us.
Take care of the business. So, you got a marriage out there, go take care of it. Divorce, if he or she is still living, get that divorce done. Yeah.
And that I have seen. Now as we leave this place, but never ever the loving presence of our loving God, may the love of God, the peace of God be with you henceforth, now and forevermore. And the people of God, amen.